Moneka Worah, ERO Resources, president of the company, been with the company for almost 22 years. Started working with Mary while she was at ERO and learned from the best on 404 permitting.
I wasn't able to make it the best.
Yes. No, you are the best. But yeah, been doing section 404 permitting for a really long time, and then assisted with the state on at least developing their compensatory mitigation program as part of Reg 87, which is what I'll be kind of focusing on during the presentation. So, welcome.
Yeah, welcome. And I'm Mary Powell with the Mile High Flood District. I was just trying to count the years. I think it's 33 years working on 404 permitting, and it never gets old because it's always new. There's always something happening with it. So, yeah. We got it. All right, I think we're just going to start. Let me make sure this thing. Well, one, thank you so much for the interest and thank you for being here. And we really do want to encourage you guys to ask questions as we go along. It's so much more interesting for everyone, I think, if we have a chance to share some experiences or share some learning. So don't hesitate I should have planted somebody in the audience to ask the first question. So but anyway, someone will be brave and they'll ask a question at some point. But in the meantime, we will try to follow, as Dave said, we're going to try to follow the Q&A in the meeting. For those of you online, if you could add your questions, there is a Q&A option. So please put your questions in there. And either Moneka and I or Dave will be trying to monitor that. So we'll hopefully be able to keep you guys engaged a little bit. All right. Okay, here we go. I like to start with this photo because it shows where there's a will, there's a way. This was a project on the Northwest Parkway up in Boulder County, the tollway, and they wanted to cross the creek here and not impact any wetlands. And they did it. They were able to design it and build it without getting an authorization from the Corps because they stayed away and they stayed out. You can imagine the corridor was fairly narrow, so they were able to put their abutments and protection far away. They just dug down and did it, and they were able to not mess with this stuff at all. So this, I would say, was a little above and beyond. Wouldn't recommend for every project you have, but it was pretty impressive that they were able to stay out of that area and avoid having a permit. So that's Permitting 101 is the name of this presentation. I'd say the first lesson is if you can avoid it, do avoid it when it makes sense. That said, Moneka, do you know one of my favorite sayings about permits and designs?
That you should design for what the project is needed and not for what permit you want.
That is right. That's lesson number 2. Don't design to a permit, okay? You'll be able to get a permit for whatever you want to design or build. I will say sometimes your project will change a little bit during the course of the permitting process to kind of accommodate some of that, but the trick is don't be afraid of getting a permit from the Corps of Engineers or from any other regulator. The system exists and we all go through it, so better just to buckle down, get some folks who know what they're doing to help you, and just it's part of the process. That's just how it goes, okay? So today we're hoping to get you through a couple of sections, primarily the Clean Water Act. I'm going to touch very briefly on sections 401 and 402, which most people are just familiar with through the NPDES permits and stormwater permits. Those things are actually parts of this Clean Water Act, the federal legislation. And then I think most familiar to everybody is the section 404 permits. And then Moneka is going to be chatting about the new state dredge and fill program, which backfills behind the section 404 program due to some changes in the regulatory status of waters of the US, which we'll cover a little bit. And then there's another potpourri of acronyms that hopefully we'll have some time to touch on a little bit. The Endangered Species Act, Migratory Bird Treaty Act, the Bald and Golden Eagle Protection Act, and the National Historic Preservation Act. And then finally, we'll hopefully also be able to get you some strategies and tips at the end that you might be able to pick and choose from to help you in your projects. All right, going to start here. So really simply, the Clean Water Act, 1977. A lot of these acts that we talk about, these environmental acts and policies and things, they all got started in the 70s. A good chunk of them happened during the Nixon administration, a Republican administration that at the time recognized we needed some controls because there really were none. I'm guessing none of you are old enough to remember when the Love Canal caught on fire. But that was one of the major turning points for the Clean Water Act when we were having places, literally the water was catching on fire because it was so polluted. So people recognized something had to get done. We also had the bald eagles becoming critically endangered due to DDT and the softening of the eggshells. And people were like, we can't have our national symbol go away. And so things happened. So anyway, most of these things were responding to incredibly significant effects at the time. And I will say, luckily, they've been very successful. Even if they get changed over time, in general, we're a lot better off than we were before all this stuff. So I give good credit to the people who had the foresight to all this on. But the Clean Water Act, very simple. Its whole point is just to protect the physical, biological, and chemical integrity of waters of the U.S. So simple, and yet so complicated. It's probably one of the most litigated acts or regulations that we have that we deal with regularly. So just real quickly, this is just kind of showing some of the complexities of it, right? Starts real easy off on the left. It's just the Clean Water Act. But then it divides, it covers two sort of different buckets of types of pollutants. One is just pollutants coming into the water itself, like just oil spills or discharges from sewer outfalls, chemicals in the water, etc. The other, the dredge or fill, is the dirt. This is the stuff that we deal with mostly in our projects. It's fill material placed into wetlands or waters of the U.S., that kind of thing. And then under it, you have the different sections. And again, sections 401, 402, and 404. I'm not going to go into much more than that on this slide because you guys don't really need to get into all the connections. But just know that there's a lot to it, right?
So wicked web.
It is a wicked web that has been woven. Yes, indeed. All right, so the Clean Water Act, again, its regulatory jurisdiction or its extent is based on waters of the U.S. And again, this has all been regulated and legislated a bazillion times, but waters of the U.S. are generally considered to be those waters that are navigable, in fact, or sometimes in possibility. You could put a boat into it, it's navigable. If it's related to interstate commerce is where the federal government comes into play with most of our laws. The federal laws, it has to have an interstate nexus for the feds to get involved with our regulations. The tributaries and impoundments of those navigable or interstate waters and their adjacent wetlands. Pretty simple. But again, every word, every nuance of this has been litigated. The word adjacent has been, the Supreme Court has opined on what that means. And it depends based on who you're talking to. So jurisdictional, again, I said this never gets old because it's always changing, and the jurisdictional status of things is always changing too. It's yes, no, maybe. Goes back and forth, back and forth, back and forth. So I wouldn't, for professionals who are in the field that don't have to sort of deal with this on the day-to-day, I wouldn't try to spend too much time worrying about it. Just know that if in doubt, find out. That's my other big suggestion there. If in doubt, find out, get somebody who knows what they're doing to help you figure all this stuff out. Any questions so far? Okay, someone's gonna break the seal at some point, not right now. All right, so one thing some of you may have heard about, we had a recent, or it's been a while now, time flies, 2023?
Yeah, 2023.
2023, gosh, going on 3 years. We had a large Supreme Court decision that changed the jurisdictional extent of waters of the US, kind of narrowed it down to really focus on those traditionally navigable waters and perennial tributaries to those waters. It took away intermittent and ephemeral tributaries and their adjacent wetlands. So if it doesn't carry water most of the year for a substantial time of the year, probably not jurisdictional. But everything I say is with the caveat of you need to make sure. You gotta trust but verify, because there are some circumstances, for instance, some of these intermittent drainageways, it's still a little bit up in the air whether the Corps will take jurisdiction or not. So there are still some gray areas. And in fact, I think I have and you guys in the room may not be able to see this very well, but what it's trying to depict is the jurisdictional status is in the dark blue is still under federal regulation. Those are those navigable waters and their tributaries and impoundments, reservoirs, et cetera, on the main stem. Some of the smaller streams are in the green. Those are the ephemeral, intermittent ones that might be on a case-by-case basis that you want to talk to the Corps about. And then all the gray stuff, the ephemerals, the stock ponds, the isolated wetlands are going to be generally non-jurisdictional under the federal system. But you know what, anymore, it hardly, I mean, I hate to say it, but it hardly matters, because if it's not under, as Moneka is going to describe later, if it's not under federal jurisdiction, it's probably under state jurisdiction. So it's much more difficult to get into that permit avoidance just based on jurisdictional status anymore. Somebody's going to get you.
All right, Mary, I'll ask a question.
Yeah, yay, Gene. Thank you, Gene.
Ditches, irrigation ditches, are they typically in or out, or is
Right.
it by case?
Yeah, that last one. It depends. Ditches, irrigation ditches in particular are kind of hard, I think, and feel free to jump in. And to be honest, Moneka these days is the more boots on the ground, dealing with things on the day-to-day. So some of my information may not be quite as cutting edge as Moneka's, but some of our larger irrigation canals are still convey water from one jurisdictional area to another jurisdictional area. And so they're kind of acting like a stream conveyance. But if they end up in an upland, or if they're typically, many irrigation canals are not going to be jurisdictional under the federal or state jurisdiction. But there are exceptions to that. So we're still in, if in doubt, find out. But I will say generally, if it has a name, the O'Brien Canal, the Bull Canal, Farmers Highline Canal, in my experience, if it has a name, there's a good chance it's jurisdictional. Do you kind of?
Yeah, I guess I would say it really then depends on where it ends. Because if you do follow it all the way and it just ends in an upland field, then more often the Corps has been saying it's not jurisdictional.
Yeah, but I find that if it has a name, it usually ends up somewhere jurisdictional, like the O'Brien's in.
Yeah, the
Bar
bar ones, like,
That's what
O'Brien, yeah. But there are some like in Fort Collins, like that are named that end in uplands.
Dinkies.
Yeah.
Okay.
It's got like a cool name, or like it's like Anderson, or
Yeah.
like ditch number 2, maybe that.
Anything with the word lateral in it probably isn't jurisdictional.
Are you gonna mention anything about the Chevron case, or is that tangential?
Wasn't gonna mention that.
Okay.
Did you have a question that you felt like would be good to?
I don't know if it's
Someone
a
asked?
question. I just would be curious if that'll affect the federal regulations in some way, because it's basically saying, wasn't that about how agencies couldn't take as many liberties with writing rules if it wasn't explicitly written in the legislation?
The Chevron deference.
Yeah.
Yeah, because like you think about lawyers writing legislation, they're not gonna write them in a way that equates to rules you can now implement for technical things. And
I don't think the Chevron decision is gonna affect the Clean Water Act because it is so litigated
Hmm.
that it has to be very explicit. I don't think there's a ton of agency,
Discretion.
discretion
Yeah.
that still is in what we deal with from a regulatory
yeah, that
perspective.
makes sense.
Yeah. I think where maybe some of that deference would come into play, but although now the law has changed as well, as like under the National Environmental Policy Act, there was more deference with some of those regulations that I think are changing.
Yeah.
So, and clean air, all that.
Okay.
Yeah. Good question, Jean. Thank you. All right, so when you're starting a project, one of the things, again, with the Clean Water Act, we want to figure out if we're working in a water of the US. And the way to do it, there's two means. One is through the preliminary jurisdictional determination, and the other is an approved one. And most often, in most cases, your project, your consultant, or your environmental compliance specialist that you work with will have a pretty good idea if something is going to be jurisdictional or not, based on their experience and what's happening currently with the regulatory agencies. So if on a preliminary jurisdiction, you're oftentimes just assuming that it's going to be jurisdictional. It's not binding, the Corps doesn't necessarily, or the EPA, give you the final determination, just kind of saying, you know what, we're just gonna assume they're here, we're gonna go ahead and get a permit, no big deal. It's not worth saying, it's so obvious that it is, that we're not gonna worry about it. Or you can have them, you could just say, we're assuming they're here, and the Corps will say, okay, that's fine. If they disagree, if you say, well, we're just gonna assume they're here and we'll go ahead and get an authorization, they can say, yeah, no, we don't think that this is actually our jurisdiction. We'd rather you not submit because it's an upland or something, and there's some things that can happen with that. But generally, you're going to have this informal thing. If you have a question about it, or it's important to decide whether it's jurisdictional or not, then we do those approved jurisdictional determinations where you do a submittal, providing your information on whether you are supporting that it is or is not. Typically, you're trying to demonstrate that it is not jurisdictional so that you can avoid the Section 404 permit. I will say though, now that, okay, if you avoid the federal 404, that just puts you right into the state. So,
Well, and I would say two things of that, the Corps is now more often potentially going to just say, even if you want to assume that it's
I'm
jurisdictional,
going to say no.
they're going to say, oh, actually, this isn't regulated. We've had that happen on projects where, no, we're not going to take jurisdiction over this. And so then you are forced to go to the state. That being said, if you do fit in something that's always been potentially non-jurisdictional, like a ditch or a detention pond or water-filled depression kind of exemption that's always been kind of a non-jurisdictional feature. If you get something from the Corps saying, yes, that is true, then that's probably all you need from the state. So it's in some instances, it'll be helpful to get that approved JD to help you avoid the state process as well.
Yeah, because actually that brings up a good point, and Moneka will go through this, but the state dredge and fill program does have lots of exemptions and exclusions. So when I'm saying if you're not getting the Fed, you're getting the state, that's a broad statement. It's a good assumption because then you can be pleasantly surprised later. But it's a good thought to have to start with. Real quickly before we get into the Section 404, the Section 401 and 402, those are the ones that regulate pollutant discharge. Gonna hit these pretty quick. 401, Section 401. This is related primarily to the, actually the Section 404 permits, the water quality certification. If you're getting an individual permit, and I'll describe that briefly in a little bit. If you're getting an individual permit, part of your process is to also obtain the state 401 water quality certification. And typically that certification is fairly straightforward to get. You provide your stormwater management plan, you provide you know, that you include in your application to the Corps. It has your best, stormwater control measures that you're gonna put in place. It's fairly straightforward. It's rare to get, at least it used to be rare, to get too much comment back from the state on the section 401. Where section 401 water quality certification can be a real issue is in large, like water supply projects or large pipeline projects. There are oftentimes where the state 401 certification process can be a real impediment to moving that project forward to, because you have to have the certification before you can get your 404 permit. And so that's a way that the state can put a little woe in the giddy up on some of these big projects. So usually it's a fairly transparent part of the process, but sometimes there are some special conditions you have to adhere to as part of your getting your certification.
Well, when you're giddy up.
I did say whoa in the giddy up, which I got from a regulator. Anyone remember Margaret Langworthy? Anybody in this room? Yeah, couple. Yeah, Margaret Langworthy said that once and it stuck.
She was like a cartoon character.
Yeah, that whoa in the giddy up coming out of her mouth made all the sense. So the other thing that we deal with a lot is section 402, and that's the National Pollutant Discharge Elimination System, NPDS. And that's where they're regulating discharge from sewer treatment facilities, outfalls and whatnot. It is also, oops, the wrong button. It's also where we have our stormwater, the construction stormwater permits are administered by the state, but it's a federal regulation administered by the state. So your stormwater permit is coming from section 402 of the Clean Water Act. And those, if anyone's worked under those, you know, kind of, they can be a little bit of a pain to operate under. To get those closed out can sometimes be a challenge to get the vegetation in place.
That's kind of funny. It almost looks like it's at the top of the slope.
I know, but look what a good job it's doing. Who's ever had silt fence that looks that good? I think this is AI.
It can't be real.
It can't be real. It can't be holding back all that sediment. But yeah, I actually put that in there because I thought it was funny because I was like, oh, that is so not real. So the stormwater construction documentation, who's had to have a stormwater inspection, like the state comes out to do an audit? Anyone? Okay, well, Dave. Anyone else? One, okay, that's pretty good. You guys are lucky. It's kind of a drag. The state could come out and take a peek, and if your stuff doesn't look like that one, you know, you can be issued some deficiencies and you have to get everything cleaned up real fast. And then you can be fined if you have some real troubles. But usually people are pretty good about keeping the records. They want to see all your inspection reports. They want to see your marked up stormwater management plan. It's a big record keeping issue. Fortunately, I'm guessing how many folks in here are in the design, or let's see, how many people here are contractors? And if you're online, if someone has a little hand, contractors versus say design professionals or consultants, most people are consultants, right? That's probably why you haven't had to deal with it, because usually it's the contractors that are dealing with the stormwater permits during construction. And so they're taking care of all the inspection reports, the SCMs, repair and so forth. So
One online hand go up.
good for you. Thank you for joining us, whoever's out there. Appreciate it. And then again, the stabilization, when you get off with the final vegetation, it's nice to move on from that. And then some groundwater discharge permit. Again, the contractor deals with that most often. Okay, section 404. Anything about those other ones before I delve into section 404?
I will say, to get a groundwater discharge permit can be very tricky if you're in like on our GLOW project, next to the South Platte River, had to go through all kinds of treatment before you could discharge any pumped groundwater. Even though the water, we're like 50 feet away from the river anyway, that's where it always goes, but you had to treat it, and that was a lot of jumping through hoops, yeah.
Yeah, that can be, you're right. Gene's bringing up how expensive and troublesome it can be if you do need to treat the groundwater before you discharge it as part of your permit. Yeah, I know, at Confluence Park, there was a big issue with that, having to treat all that groundwater. And you're right, it can be a substantial additional cost to the project. So hopefully it's not a surprise. All right, let's move on. So the section 404 discharge, it's a regulatory program that covers and regulated action that occurs in a regulated area. And the regulated action is the discharge of dredged or fill material. And the regulated area is waters of the US and adjacent wetlands. This sounds so simple. All right. There's two types of permits that we work under. There's the general permits, which are activity-based, and there are individual permits that aren't covered by general permits. And the individual permit is a project-specific permit. An example of general permits, how many of you have heard of nationwide permits? Most of us? Okay, great. Yeah, nationwide permits are very common. They are specifically, I mean, they kind of describe what they are. They are activity-based permits that are issued nationwide. So by activity-based, I mean, each permit, and there's about 50 or some odd of them, there's a ton of nationwide permits, and each of them describes an authorized activity. For instance, an outfall structure. And it describes what that means and what you have maybe some thresholds on impacts. So you have an activity, and if you meet the description and you meet these thresholds of impacts, your activity could be authorized under that nationwide permit. Another one is like crossing structures. Somebody has their hand up here.
David, that's it.
Oh, okay, sorry.
Okay, would you like to ask a question, or are you just raising your hand to say you've worked with nationwide permits? History. Yeah, all right, sweet, thanks.
Good on you, thank you. So activity-based includes bridge crossings, utility crossings, help me out here, recreation facilities.
Stormwater management facility.
Anyone else? Who else has one out there?
Repairs.
Pardon? Repairs,
maintenance.
maintenance activities and certain
Utility lines.
utility
You
crossings,
say the road crossings, yeah?
road
Which
crossings,
one's that, 42?
14.
14.
14.
Oh, bank stabilization, 13, right? Cranberry production, anybody?
Is that a thing?
That is.
Heck yeah, that's a thing. Cranberry production.
Very useful here in Colorado. The one for nationwide 14 for roads, how far upstream and downstream of the road crossing does that give you? Is it like 200 feet or something?
You, sir, are thinking of sediment removal, nationwide permit 3, part B, where you get
200 foot.
200 linear feet above and below a structure.
The 14 just says something to like the minimum necessary for that crossing.
Oh, we get to use judgment. That's great.
Yeah, yeah. So obviously, just from that little conversation, there are a lot of them, and you you want to make sure your project is meeting it, and that's again where your environmental compliance person will help you figure out if yours is covered or if it's not. Another type of general permit is the regional general permit. And the best example of that is one that the Mile High Flood District holds. It's called Regional General Permit 7. Has anyone worked under an RGP 7 that you're aware of? Gene? Excellent. Some of you probably have and you just don't know it, if you've worked on a district project. We've been lucky to have that such that we've been able to avoid an individual permit. Apparently close to 20 some odd individual permits we've been able to avoid, which is great because the individual permit is really the bear of the whole permit system. Just because it has a lot of requirements, it's a very time-consuming, arduous documentation process to get through the individual permit process. So those are nice if you can avoid it. That's nice. But you know what? If you have to get one, just dig in and eventually you'll probably get one. So I wouldn't avoid it, but it does have a big deal to it. Yeah, question here. Yeah.
With the nationwides versus the RGPs, is it the Corps who decides which one? Like, you don't have both? That one, I remember working under like an RGP 12 was maybe like fish habitat or something, but it could have also maybe been nationwide. We thought as, amateurs who aren't the permitting experts, but how does that work? Do you get one
Yeah.
or the other?
That's a good question. The question generally is, how do you know what your activity, if it's covered under a nationwide or a regional general permit? And that's where you do contact the Corps. They have the final decision on determining whether your activity is covered under nationwide or if it's better covered under a regional general permit. And usually the regional general permits typically have larger or greater impact thresholds. So they might cover a little bit more of an extensive activity. But in my experience, they tend to cover you under nationwides if that fits. So just know if that helped or not.
Thanks.
Question.
Oh, yeah, there was another one.
Mary, do you generally consider a letter of permission as a general permit, an individual or somewhere?
See, letters of permission are not very common in my personal experience. I don't think I've ever gotten one.
We use them a lot. They allow a higher impact threshold than a nationwide permit, but it's not nearly the time-consuming effort of an individual.
And you used to work at the Corps, right?
Yes.
So you know all the ins and outs.
I do.
Yeah. Did we get an LOP for that one, that pond? Yeah, I don't think we did, but
They ended up letting us have an RGP, but the letter of permission was in the talks.
because they're just not that common. Do you ever get them?
Mm-mm.
We do on the west slope with the Grand Junction office quite often.
Yeah, I think sometimes, I think one of the issues with the Denver regulatory, and another thing is every Corps office is different. It's like a different culture. And Colorado has 3 main regulatory offices. And we deal mostly with the Denver regulatory office. They tend to be very, very hesitant at exceeding the nationwide thresholds of impacts. So that may be why I just haven't run across them, because to them, it's like, nah, no thanks. They don't like to make, well, no, I shouldn't say that. Yeah, they're just loath to do that.
Yeah, a lot of times when it has that, like, unless the district engineer waives, and whenever we've asked, can you waive it, they've been very reluctant.
Yeah.
To do that,
Yeah.
at least in the Denver office.
Yeah.
Could you also speak to who the permittee, who's applying for the permit and how much that weight plays into what kind of permit they're likely to be able to get?
No, we can touch that on the next slide. It's getting to I think the purpose and need statement, and who's coming in, bringing a project to the Corps. Before we get there, cross your fingers and we'll get to that. First, I just wanted to touch a little bit more on the general permits, the nationwide permits. I guess I was wrong. There's 60. I know that number's right because I looked at the permits the other day when I put that number in. Of the 60, which includes cranberries, we use maybe 15 pretty regularly. It's the maintenance, it's the outfalls, pedestrian crossings, trail, that kind of thing. So we don't use nearly all the 60. Yeah, go ahead.
What's an example of when you would need an individual? Like, it seems like outfalls bank stabilization bridge, like, when do you cross into the individual? Is it a combo of all those things or like?
Yeah, no, that's a good question. The question is what triggers an individual permit? And I haven't mentioned it, and I don't know if I have a slide that says it, but some of those, when I say impact thresholds for nationwide permits, typically for impacts to waters of the US can't exceed half an acre. So if you have a large bank stabilization and the bank stabilization, like nationwide permit 13, has a linear footage threshold as well. So you have the impacts to waters of the US, and if it's longer than, is it 300 feet, 500?
500 feet.
500 feet long. If it's 501 feet long, sorry, individual permit. So if you have a bridge crossing like Dave's Bridge, only gets a nationwide if the permanent loss of waters to the US is half an acre under.
So, or if, a stream restoration or stream
Yeah.
realignment project where you're not in the district boundary, so your Colorado Springs or your Fort Collins or something like that. And you can't, they don't agree, it's a nationwide 27 because they don't think the realignment is necessary, or I don't know, something like that, that can trigger individual permit.
Yeah, so the, again, the impact thresholds a lot of times are related to the notification. Most nationwide permits you're gonna have to notify on. There are very few that you don't need to notify the Corps and let them know what's going on. If you happen to be in a situation, and I think this is really important, a lot of people don't understand this. If for some reason you happen to hear, oh, I'm working on a project that didn't need to notify, we're in a non-notifying nationwide permit, we didn't have to submit anything. Great. You are still working under a permit. You just didn't have to tell the Corps about it. It's a really important distinction. You still have to adhere to all of the thresholds and activity limits, and you have to still adhere to the general conditions that are associated with that nationwide permit. It's not a pass.
And I'll give one quick example that is just, it came up just last year. That a client was doing some work at an intake structure, an existing intake structure and infiltration gallery, doing some sediment removal maintenance, and it fit under the maintenance activity. But that is, like Mary said, still a nationwide permit. You have to follow all general and regional conditions. And one of those conditions is that you're avoiding spawning areas. And they didn't think about that condition. And then CDOT was in the area and, found out about it. And so then, was potentially looking at a violation. And of course, we were able to help them and talk to the Corps and say, this is what happened, this is what they're gonna do. But it's just an example of like making sure you're reading all those regional and general conditions.
What would you do in a situation where maybe in your design, you're within the threshold amount? And then you're part of construction activities and all of a sudden the contractor does something unanticipated. And now you're getting close, if not over the threshold. And maybe now you're into another permit. What would you do in that situation?
Do you want to take that?
I would say call, if you have somebody who's helping you, a consultant with the permitting, call them and then try and coordinate with the Corps immediately if you're exceeding those thresholds to see if you could get a authorization if you're going to exceed those thresholds.
Yeah, it would be a bummer if you were exceeding it and getting bumped to an individual permit. I would try really hard to make that contractor put that back. Thank you. And still disclose it to the Corps, because and here's another, this is a tip, pro tip number
So
2.
restore it. Try to look like you hadn't been there, but also.
Yeah, yeah,
Disclose it.
yeah,
Yes.
disclose it. It's not worth trying to just always be forthcoming with the
Yeah.
Corps. It builds credibility and it keeps you out of trouble. But yeah, if it's something that could be repaired, then absolutely fix it. But if it's something that like you have a design change that must be done and suddenly bumps you up, yikes. That could kind of be a bummer. You would have to get a permit. You probably have to stop work. Or you could try to maybe you could ask them if they would please, pretty please, let us exceed the threshold because it's so tiny, and maybe they would give you some after
Use this language.
fact authorization.
If it is more on like you're exceeding the mitigation threshold now, then it's again, letting the Corps know and having to like buy mitigation bank credits, right? Like, and the Corps will hold you to those. Like if you said, oh, I'm gonna put impact, and I know we're probably getting into mitigation more, but oh, okay, if you're going, like the threshold for mitigation for wetlands is a 1/10 of an acre. So if you have 0.09 and then your contractor impacts more, you need to, again, be forthcoming to the Corps and then potentially buy the credits that you need, because they have come out.
That's very.
That part of the permitting too, I remember a long time ago writing stuff where it's like this many temporary impacts versus permanent.
Yeah, that's a good question about impact thresholds, temporary versus permanent. The nationwide permit impact thresholds are related to permanent loss. of waters in the US. We typically also disclose the temporary ones, just to be above board, but there aren't any thresholds, for those. But temporary, and it's back in the day, way back in the day, temporary used to just mean you could put them back where they were. And maybe they're higher or maybe they're lower. But they're right there in the same place. You could see them. But that is not the definition of temporary. Permanent loss is if you change that elevation, even if wetlands come back, they're lower or higher, that's a permanent loss. So you have to be careful. But yeah, temporary impacts don't count towards that threshold of half an acre for nationwide permits. Permanent loss.
Very specific though, what's temporary, like.
Yes, it's very, they're very tight on what that means.
Wiggle room.
Yeah, it absolutely, you would want to contact them and work it out.
Did you have a
I was
question?
just gonna comment that, regulators have very frequently required mitigation for extended temporary impacts. So I've been getting asked duration of temporary impacts, and if it's gonna exceed 6 months, they'll make us do mitigation for it, buy mitigation credits at a 1-to-1 ratio. But it really depends on the regulator, so just be
I
careful.
haven't run into one of those.
That sounds made up.
Judgments.
The Denver office hasn't been doing it, so.
You say they have or have not? Okay, good. I was just saying, I haven't heard that yet.
I called Kyle.
Yeah, that's, I'd be on the horn pretty quick. Yeah, well, it just speaks to the fact that you just don't know what you're getting into. Don't assume just because you do one thing one place, they're gonna do the same thing somewhere else. And don't assume one person, I mean, you know, everybody has their isms, right? You just never know the personality within the office, so it can change a lot. I'm gonna probably move through some of this pretty quick. The nationwide permit pre-construction notification. There's a bunch of things you're supposed to do, and so talk to that environmental compliance specialist and they'll help you get your packet together. Okay, less is more. Just the facts, ma'am, don't submit a ton of stuff they don't need. If you could do the online, there's a nice online submittal version now. So quick and easy, and it really cuts down on all the blurbage that you might be tempted to otherwise submit. They kind of force you to just keep it to the minimum, I think. Regional general permits, again, I already talked about the district's RGP 7. Only the district, only Mile High Flood District can work under that. We applied for it. In fact, it's up for renewal. These RGPs are renewed every 5 years. And so same with the nationwide permits, those are renewed every 5 years as well. And we just renewed them in 26. So we're good for 5 years. RGP 7 is getting renewed. Moneka is going to be helping with that. So hopefully that'll continue. And then these others are other statewide regional general permits that are out there, but some of them don't make sense, to be honest. They kind of, other nationwides cover them.
One thing I want to mention about the RGP, getting back to something Mary said earlier about your reputation and credibility with the Corps is hugely important. Everybody's on this call or in this room probably because you interact with permitting, whether it's Corps or other kinds of permitting, but your credibility with the regulatory agencies is hugely important. And the only reason it's even a possibility to have an RGP 7 is because of the long track record we developed with the people at the Corps. If the opposite were true, our lives would be really, really hard.
There'd be a lot of individual permits.
A lot of them.
If you had a sense of like the time and money scale difference from nationwide to individual, like ish, is it like 2-3 times as long, 2-3 times the cost, or what are we talking?
Probably 2 times at least the length to get the permit, I would say. You think 3 times? Yeah, depending, right?
More
I
times
mean, it does
long.
depend on the project. And then cost wise, yeah, maybe at least double.
For the same size project. Like all things being equal, right?
Yeah.
You know, not like, oh, it's big, so it costs more just because we had a big
The
delineation.
cost for the regulatory effort.
Yeah,
Yeah. For putting more into that application.
Mhm.
and then there's just the pain and suffering. On top of that. It's immeasurable. And to the, Alex online mentioned, having to get an IP, an individual permit on a kayak project. So it does happen where it exceeded the threshold and had to get an IP, so I'm really sorry about that. So individual permits, again, this is gonna get back to Dave's question about, whether it depends on who you are. Quick question?
Well, it's kind of back to when you said that nationwide had to get renewed. I was wondering if you could, you said that a little bit, like you have to renew. So no matter when you get a nationwide permit, you have to renew it on that 6th year, not like 6 years.
Well, you wanna, you can answer.
Sure. The nationwide they are nationwide renewed every 5 years. So they're either reissued, revoked,
You
revised.
don't have to renew.
Yeah.
Um,
Well, so they just
Who's that- who's
expired,
that- Who renews them? Who's the-
the Army Corps of Engineers.
So do they, if you have a project that had one,
So the old nationwide permits expired March 14th, 2026. If you had a project that was not under construction or under contract that had gotten a nationwide permit, and you didn't have a contract for it, or you weren't under construction yet, you need to get it reauthorized under the new nationwide permit.
you have to get a brand new one.
But if, yeah, and it's just, it's really easy. You can even just email them and say, nothing has changed. We just need new authorization because we're not under contract or under construction. If you are under construction or under contract by that March 14th date, then you have 1 year to complete the work. And then if you don't get the work completed within that year, you need to ask for a reauthorization.
Gotcha. Okay, that makes a lot more sense.
When they do that reauthorization every 5 years or 6 years, whatever it is, are they making many changes generally to the nationwide permits, or are they?
Most
usually
of the times,
pretty-
the ones that we're under, they're not tweaking to a significant.
But the cranberries, who knows?
Exactly.
Yeah. Cranberries.
Right there.
Yeah, that was a good question though, because it's important to track the expiration dates of these things, because some of our projects last for years, right? And so you do have to be a little thoughtful about when you're gonna submit. Like the last, in the fall, there was a lot of discussion. Well, where are we with these projects? Should we request new authorizations, or are we under contract? So you do have to keep track of them.
But if you need it to roll over, it's as simple as.
As long as there's nothing changed in your.
And you're still meeting those new nationwide permit thresholds and descriptions. An email would be the easy button, but it's easy. It's pretty straightforward. Nobody wants to make it hard. And that's the thing too. I mean, the Corps of Engineers, all they want to do is issue you a permit. That's their whole, the regulatory office is there to issue permits, and they will do what they can to help you do that within their guidance and regulations, so they're always happy to find the best way to get your project moving forward. Always want to stress that.
And then individual permits, in my experience, the default duration of them is like 2 years.
It varies.
It varies.
But yes, I think that's their default.
Default's 2 years. So if you have I have a project that's in construction that's gonna be longer than 2 years. And I have a little remind you this spring, like, hey, let's ask for an extension on Brent's Landing.
Yes. And I have, that one we probably should, but I have like on Happy Canyon Creek, we asked, when it was gonna be an individual permit, could we make it a longer time period, knowing the project was gonna be in phases and could take longer, and they were amenable. And so it's just a conversation with them.
Ask.
Yeah, ask.
And actually, when, was it Margaret Langworth? Yeah, with her, I had happened, back then I had to write a request permit. We had a bunch of little separate little things were happening out in Rock Creek Development or whatever on Superior. And she told me, well, just combine it all in one. So I summarized everything in one big thing. And I actually put in that letter, like, oh, we don't expect all development to occur until such and such a year. It was like 15 years and she honored it. It was just
They
great.
used to do
Yeah.
that more. I had
Yeah.
a project that had a 15-year authorization, and I don't think that would happen these days.
But she was like,
Yeah. Those are the good old days, Gene.
Shall you ask?
That-
What I heard.
that's right.
Yeah, that's the other thing too. What is this, pro tip 3? Don't say no on behalf of the Corps or any other regulator. Don't assume the answer is no. Let them tell you no, because sometimes they actually say yes and surprise you. So never say no on somebody else's behalf. Let them tell it to you. You may as well ask. You know, I call it the Roomba approach. Just keep trying and find a corner that you didn't find before, and suddenly there's your yes. So, real quick on the individual permit. This is for projects that don't have one of those activity-specific authorizations. So here is an example, and I'm going to make this comment. They're soliciting comments right now on the next round of nationwide permits. And my comment is going to be, darn it, we need a nationwide permit for drop structures. There isn't one. I mean, come on, a drop structure. You can build a bridge, you can, you do all this stuff, but there's nothing for a drop structure. Surely we could get one, right? So a drop structure, you might have to get an individual permit for that. Now, it's simple enough that it probably wouldn't be a big year-long, thing, but you would have to get one, and you'd have to provide all that extra documentation, and you'd have to have it alternatives. The thing with the individual permit, you have to submit a lot more stuff. The first thing you have to do is prove to the Corps that you need to get into the water in the first place. You have to prove through your purpose and need for the project that you can, there's no other alternative other than having to get into the water of the US, that regulated area. Can't avoid it. Their starting position is, yes, you can avoid that. It's called the rebuttable presumption of avoidance, and you have to prove that you can't avoid it. And for some projects, that's hard, like a big water project. Prove to me you can't build a reservoir in an outlet. You can. Hard. You can do it. So it's hard to demonstrate that you actually have to dam up a river to make a reservoir. You could dam up an empty canyon and divert some water into it. That's different than damming up the river, right? So a lot of times, like, developers have a real hard time if they have activities that exceed the nationwide permit authorization. They have a hard time getting an individual permit because the Corps says you can build all the houses you want without getting in that creek. The developer says, oh, but I have to, the local government's making me do all these stormwater management improvements, these channel improvements that the Mile High Flood District says we have to do in their master plan. And the Corps says, well, that doesn't have anything to do with your actual wanting to make money from homes. Your purpose and need is residential development. And the developer said, but we can't get our project approved if we don't do this work. And the Corps will say, well, go buy a different parcel that doesn't have a creek in it, and you can build your thing there. And the developer's like, but so anyway, it's hard if you don't have a good purpose and need that drives you into the water. So, and again, with an individual permit, it's a little bit different than a nationwide permit. Nationwide permits are kind of issued on the assumption that altogether nationwide, their impacts are not really significant. They're minimal in cumulative, minimal adverse effect cumulatively nationwide. With an individual permit, you have to have your project have the least environmentally damaging, practicable alternative before you can construct it. And that's a hard hurdle to demonstrate. So it's,
Is financial impact considered at all the purpose and need?
well, practicability includes cost, logistics, and technology. And I will say the cost piece can be a factor to demonstrate that it's not practicable. Like for that development thing, I've had to be involved with a pro forma that the developer had to they had to do this big economic analysis on real estate evaluation, why, the economics, it has to be more than, oh, it's a little more expensive. It has to be a substantial.
I think the Corps has said in the past, like 3 to 5 times the cost for it to really be, and you have to do a detailed cost analysis to demonstrate that.
Yeah, they send that stuff to their economists to review. So it's not just like, oh, yeah, it's so expensive. It's tough. That's the hardest one to get the practicability test through.
There's a big battle amongst economists.
Yes, yes, would not recommend. This is the last slide on the section 404, and it actually works a little bit with Moneka's part as well, and that's the mitigation. And mitigation is,
To plan.
to me, it's one of the more frustrating aspects of the 404 program, the way it's currently implemented. And I say that only because I'm coming from my perspective, from the district and the projects that we do, which in my mind, I think leave things in better shape than we usually find them. Not always, admittedly, but we oftentimes have more wetlands, we have better streams, but we're often pushed to being required to purchase mitigation bank credits. The reasoning is after you've been able to avoid, minimize as much as possible your impacts, you do want to try to avoid and minimize. And I give credit to a lot of great design people, great teams that can come together and work to figure out ways to change plans to minimize impacts. It's great. I think people think of it as a challenge. Like, how can we change this plan a little bit and maybe not do the full meal deal, be more surgical? And so if people look at it as a challenge, I've seen some amazing reductions in impacts because people took it as a positive thing. So some good things come out of it. But if you can't avoid, and once you've minimized, then you need to compensate for your impacts in most cases. In nationwide permits, if you can keep it under 1/10 of an acre of impacts to wetlands, you can avoid mitigation. You can keep your stream impacts under the size of this table, you can avoid mitigation. It's 0.03 acres of stream impacts, which is very little. But so once you do that and you still have to mitigate, you can't avoid, then the Corps has, this is just by rule, they don't really, they do have some discretion, but they're, tend to be fairly narrowly exercising that. The first choice, if it's available, is you have to purchase mitigation bank credits. If it's not available, and in Colorado, we have a lot, they keep coming more online. So lots of credits out there, and they're great for certain projects. There are some projects that should not do anything but buy credits. You have a development, and this is going to be true in the state system as well. If you have a development with some small patches of wetlands, or you have a small creek, and you need to do your project, it's so much better for them to buy credits in an established wetland bank than try to recreate wetlands and maintain them on their own. It takes special knowledge. You've got to manage them properly. They're small, oftentimes little dinky, isolated, fragmented things. And so there are situations where the credits is great. Yes, they're expensive. They're like 150 now. About $150,000 an acre. But if you think of land, 170, okay, 170 an acre. If you think of land cost, design, construction, monitoring, maintenance, it's an easy button to get out of all of that. So in some cases, it's a great idea. I personally, for our projects, do not like to buy mitigation credits if I can avoid it. Yeah, there's a question.
Okay, so if you're buying credits, where does that go to on the other end, I guess? It's like, it's a weird exchange to me. You're buying a credit. What does it do?
Who
Is
gets
it,
that money? And
yeah, what happens with that? Yeah.
Private entities that have put together mitigation bank projects, and so they are getting that money.
Yeah, so good question. I was assuming, so a mitigation bank credits, commercial banks, they are entities that have gone out somewhere and built wetlands or have restored streams. And so they've spent their money, they put money in, they've got water, they've got land, all that stuff. They construct these things, they work with the Corps, and it's a laborious process. It takes years. I can speak personally, it takes years. And then they create certain acreages of wetlands or streams, and they figure out how many credits. Typically for wetlands, it's an acre is a credit. For streams, it's a functional foot. So these things exist out there. There are banks, wetlands that have been created, and what you do is basically compensate the banker for their output.
Okay.
And they make money.
And you can negotiate the cost, and it maybe is actually getting a little bit more ability to do that because there's more competition. When it used to be, maybe there's only one bank in the Front Range area, they had the market, so they could charge whatever they wanted to. But now that there's maybe 2 or 3 banks, they gotta be competitive.
Is it regional or is?
There, yeah, that's a good question too. Banks have what they call service areas. So the farther, and the service area is defined in negotiation with the Corps of Engineers. It's usually watershed based. So there's certain commercial banks that you can buy credits if you're in their service area. But the farther away you are from the bank location, the higher your mitigation ratio. It used to be, it was 1-to-1. I impact an acre, I buy an acre. Or I impact an acre, I make another acre. Now there's ratio calculators. And so the farther you are away from the bank, the more you pay. And there's all sorts of other factors that go into the quality of the wetland you're impacting, et cetera, et cetera. It's quite, and that's where the Colorado comp on this slide here talks about determines the mitigation ratio. There's a worksheet and it's, it's always a little bit of a mystery what's going to crank out of the sausage maker on your ratio. And that's can be, the unpredictability can be a little frustrating, but yeah, I'm in the process of creating a mitigation bank for the district because I just don't want to offsite our functions that we have in our streams here in the metro area. Bugs me to buy credits somewhere else on streams and wetlands when we're doing good work in the district and we're making things better. So I'm making a bank so that we don't have to buy these credits anymore. Knock on wood. We have our first project coming online soon. Hope. So we're continuing to work on that. But and sadly, unfortunately, it's only for us. It's too much trouble to make it a commercial bank or make it usable for other people. So sorry. Just our RGP and it's just our bank. But hopefully if we're working with partners, local government partners on our projects, then they can take advantage of that.
Mary, I think Abby had a clarifying question.
Yes, and I believe it is that where the bank is in the watershed, and then if the service area, again, if you're in that primary service area, then you more likely are going to be able to get more of a 1-to-1. But if you're out of that service area, and then depending on the distance of how far is where the ratio would come.
Thank you. Thank you for that clarification.
And then I'm assuming Molly's question, where's you?
Oh, our bank. It's a secret. The first one we're doing, the first project is actually a stream mitigation down in Highlands Ranch on east Clark Gulch. Yeah. And ironically, it's in a non-jurisdictional area, which cracks me up. You could do mitigation in non-jurisdictional areas.
We're gonna make it jurisdictional.
No,
No.
Well, once it's a bank though, then the core.
no,
Okay.
no, but thank you.
We're gonna set it.
Okay.
Carry on.
All right. Any, that was like a fire hose, sorry. Any questions? But keep in mind, Moneka's going to say a lot of stuff that's going to echo this, so hopefully it'll get into your brain. A lot of what we've talked about, fortunately,
Applies to the state.
applies to the state. So, so unless there's a specific question, I'm going to go ahead and hand it on to my colleague. All right.
Wait.
Wait.
No, we got this. Right now. Not again.
There we go, state and
Wait,
dredge.
he did that.
You have it on?
There we go. Yes.
Okay.
Technology.
Is it plugged in? Yes.
Okay, I'm gonna switch now to the state dredge and fill permitting program. So the similar to section 404, except now Colorado Department of Public Health and Environment, specifically their Water Quality Control Division, will be issuing permits for in the state water. So the regulation that's gonna be the authorizing regulation behind this program is Regulation 87. It is was created based on HB 24-1379. So that was a bill that would pass through the legislature in 2024 to create a dredge and fill permitting program. And the idea behind this started in the first Trump administration. when they first put out their revised Waters of the US rule, and the state realized that under that rule, they would lose a lot of protections for wetlands and other waters in the state, and we're concerned about that. So they started the process, I think, back in 2020, got a lot of maybe pushback and concerns from the public, kind of put it on pause after the Trump administration ended, but then knowing it potentially could come back again, they restarted the process in 2020 after the Sackett decision. And again, understanding that Sackett was also going to reduce the federal regulations for protecting state waters. So the regulation 87 was created in 2024, 2025. They did a lot of stakeholder involvement and in those years, and then drafted the regulations in the second half of 2025. There was a public hearing process in December of last year, and they made some edits to the regulations based on those public hearings, and then officially approved Regulation 87 on February 6th of this year. So the regulation itself establishes the requirements, prohibitions, and standards for discharge of dredged or fill material into state waters. And then again, outlines specific exclusions, exemptions that I will get into, and requirements for mitigation.
It's confusing. We don't
I
do
know, I'm really wanting to do it on my
No.
computer. So this is the general outline. Again, I'm not gonna go into the details for every single section of Regulation 87. I will put into the chat, where you can find this. It's not easy to find this actual clean version of Regulation 87 yet. It really should be on Water Quality Control Division's website for the dredge and fill program. But it's right now, I believe, only under the Water Quality Control Commission's website for their public hearings. And then you can see both red line versions and then clean versions of the actual act or regulation itself. So what is state waters? There's actually been a definition of state waters for a while in Colorado statute, but we haven't really worried about it because there have been no regulations associated with it for the most part, as far as when it comes to streams and dredge and fill activity. So the definition of state waters is quite broad, and it means any and all surface and subsurface waters which are contained and or flow through the state, but does not include waters in sewage systems, treatment works of disposal systems, waters and potable water distribution systems, and all other water withdrawn for use and treatment have been treated. So the program now applies to all state waters, which is different from what has been under the Clean Water Act in Section 404, and that there's always been a certain level of what is waters of the US. So isolated wetlands, isolated reaches or any high water mark have really never been regulated at the federal level.
Well, not
Okay, not
since
regulated.
you were not born.
That's true, that's true.
I mean,
Long time
literally,
ago.
wait.
Long time
Oh my
ago.
God. Yeah, they used to regulate isolated waters.
That's true, they
wetlands,
did,
yeah.
they did.
And you could impact up to 5 acres.
Yeah,
Those are the
that's true.
days. Those-
But knowing that for the last 20 years, they have not been regulating that, the state is now taking more jurisdiction over what then has not been regulated recently, I should say, recently. So with that, they added a lot more exclusions and exemptions. So there's a lot of exclusions in which if you are in these type of activities, you do not need authorization from the state. So all portions of ditches and canals that are excavated in uplands, well, I should have put this right below, also wetlands adjacent to a ditch or canal. They have a specific definition of adjacency for that. And it basically is saying any wetlands that would cease to exist if the water from the ditch was absent. So if you have a wetland adjacent to a ditch, but it's not actually supported by the ditch water, it still potentially will be regulated. But again, those kind of fringe wetlands along ditches are not regulated under the state program. Stormwater control features, to convey, treat, or store stormwater and are created in uplands. Artificially irrigated areas that would revert to uplands if irrigation ceased. Artificial lakes, lagoons, or ponds created entirely by excavating or diking dry uplands to collect and retain water that are used exclusively for stock watering, irrigation, settling basins, or rice growing.
Cranberries.
Yes, and again, a lot of this is language that is also in the federal program of what is usually considered non-jurisdictional. Artificial reflecting or swimming pools or other ornamental bodies of water that are in uplands or created in uplands. Water-filled depressions created in uplands incidental to mining or construction activity and pits excavated in uplands for obtaining fill unless abandoned. So once they're abandoned and they develop wetlands, then they may become state waters. Swales and erosional features, groundwater, prior converted cropland. If you're in any of those type of waters, then you do not need authorization from. There are a lot of exemptions as well. So if you have a 404 permit that was issued prior to May 25th, 2023, you do not need authorization. If you have approved JD issued by the Corps prior to May 25th, 2023, stating you're not in waters of the US, then you also don't need authorization. I thought maybe they'd be holding more to an active JD in that time period, but they have, in my experience, now been saying that you are exempt even if you have an older JD. So I had a project that had one from 2017. So they really should have reissued that JD in 2022, and they did not. But the state granted them an exemption because it was considered non-jurisdictional in 2017. Activities in receipt of a 404 permit that was issued after May 2025 or 25th, 2023, except if you're in an area that has been determined not to be waters US. So if you have gotten a permit for some jurisdictional water body, but then you have an adjacent wetland that maybe the Corps didn't take jurisdiction over, you may still need an authorization from them.
So, and just to be clear, that means you could be in a situation where you need a federal and a state
Yes.
fill and discharge authorization.
Activities associated with an IP application prior to May 25th, 2023, that may no longer be that applicable for. Normal farming activities, maintenance activities. Some more exemptions. So construction or maintenance of farm ponds, stock ponds, farm lagoons, springs, recharge facilities and uplands, construction or maintenance of farm roads or forest roads, or temporary roads for moving wildfire and post-wildfire mitigation. So I think they understood that sometimes when we are having more fires or flooding activity, there might need to be some emergency activities, so those would be exempt. Maintenance and off-channel reservoirs, voluntary ephemeral stream restoration activities. This does have specific definition to it of what that restoration is meant to be. And there's limits to it. You have to show that it's ecological lift. I believe you can't have grout or riprap associated with it.
No, riprap you can, I got that.
Oh, okay, you got riprap.
No
okay.
grout.
No grout. So if you do think you are in an ephemeral stream when doing some restoration, look at that definition to really see if you truly fit under that or not. Construction of temporary sediment basins, emergency response activities to fire, flood, or other natural disasters, wildlife habitat management activity, and then maintenance of water reuse, wastewater facilities, water management facilities. Yes.
Can you define voluntary and voluntary ephemeral stream restoration activity?
So that's a good question on voluntary.
It means you're not doing it for mitigation for something else, or it's not required for some other
Entity,
regulatory or
yeah.
entity. Yeah, it's really focused on those like, volunteer events in public lands or private ranches. They had a pretty specific idea about it, but I would be making the case that the district is doing a lot of voluntary ephemeral stream restoration activities if we end up in that situation, so.
Upland. What is the definition of the upland regarding the ditch or channel?
Question, what's the definition of upland? If something's constructed in an upland, it generally means you're not in a regulated area, which would be a wetland, or we haven't mentioned this phrase, I don't think. Ordinary high, well, you mentioned it once, isolated, ordinary high water mark. Those are regulatory definitions of the regulated areas. So an ordinary high water mark is present in an ephemeral stream or an intermittent stream. That's where the state is taking their boundary. Maybe dry, it's not a wetland. To me, an ephemeral ordinary high water mark is kind of sus. But, you know, what else? But yeah, it's, it depends on, you're not in an ordinary high water mark.
All right, so let's say there is a rocky mountain ditch, for example, or whatever, the main ditch, right? And it's taking the water, has the sluice gate, it's taking water in the summer, somewhere else. Is it upland or it's not an upland? Like,
Well, if it was constructed in upland, so if the ditch looks like it is following more of a contour and going through an upland area, then that section may be considered not, you know.
all right, so we will be like above, like, let's say 100, what's that? 100 is the elevation of the high water mark. And if I have a contour that it's above that, this will be the upland. But if the contour is below that, it will be not the upland. Kind of trying to just figure out.
Yeah,
I don't
yeah.
understand what is the upland and like,
Well,
will this apply to this ditch canal or whatever or not?
it's kind of like, imagine when you first were gonna build the ditch.
Yeah.
Did you have to dig through a wetland to get the water from place to place, or was it an upland when you dug that trench? So if the area prior to any disturbance didn't have a wetland and it did not have an ordinary high water mark in it, that means you can't use an existing ephemeral stream to act as your conveyance, can't improve it, because that would be within the ordinary high water mark. So it's really asking you to like use your time machine and go back and, well, you know, was it upland? And usually you can tell, you know, it's usually pretty obvious, but ditches and such, get somebody to help you knows, because it is, to me, it's
Case dependent.
it's case dependent, case by case.
The question on the chat on sediment removal, as part of maintenance, that is a good question. They could see it as an exemption, but they could also see it as under like nationwide 3.
They don't. They haven't seen it.
Oh, sorry. Oh, yeah. The question was, would sediment removal as part of maintenance require a state permit? And I think it could go either way, because they do say maintenance is an exemption, but there is also a nationwide permit that says sediment removal is a maintenance activity, but it triggers usually a pre-construction notification. So they may see it as something that you actually do need to get authorization for.
What does maintenance mean to you? Yeah.
Yeah, yeah. And it's such a new program that I think it really is kind of trying to figure it out as they develop it on what side they're gonna go for some of these issues.
Here's a question.
I have a question about, like, in the voluntary, like we do a lot of projects with Mile High, and it's like, if you're just finding them as voluntary, but you're doing, like, one of the streams I was on, Goldsmith Gulch, or excuse me, Harvard Gulch, they dredged it, right? Because there was a lot of sediment disposition, and it's causing, an increase in water surface elevation. So they dredged a little bit of it. So like, that kind of like, you're doing dredging, but it's in a voluntary area.
I would say on that one, I'm a little familiar with that project. I would say the purpose of that project wasn't necessarily stream restoration
Right.
per se. To me, it was more a flood conveyance. The sediment was getting in the way of the capacity of that part of Harvard Gulch.
Right.
So if I was a state regulator, I'd be like, probably not. I think the voluntary restoration piece is really, hey, you have a degraded stream in a overgrazed, grazing land, right? And you want to fix it and make it better. You have a degraded stream and you're going to raise it up, raise that invert to try to make it better function. Of course, it's ephemeral. Sorry, this whole ephemeral thing is just like, I don't get it. But, so you're restoring an ephemeral stream to try to make it be better dirt.
We'll keep going.
Yeah, keep going.
So there is now a form that you can complete to see if you fall under an exemption or exclusion. I would highlight the first sentence that is here, that this is from their website, that a project proponent is not required to consult with the division on whether your project qualifies as an exempted activity or is an excluded water feature. So if you are, using a consultant, or you feel confident you fit into one of these, or you've gotten something from the Corps that says that you fit under one of these, then I would say you're usually probably good, unless you or your client really want that piece of paper that says, for sure, we don't need anything. And then if you do want that piece of paper, you can fill out this form, and it basically is saying which of the exclusions or exemptions are you trying to apply your project to, and then provide evidence or documentation of how you fit under that. So that is possible, and there is, again, that email address that you can ask them questions at. So general authorizations, the state will be issuing general authorizations, I believe, by September of this year. Because I think in the regulation, it said that by August, the temporary authorizations would be. They will be based on the 2021 nationwide permits, just because that's what they were using when developing these, I believe. And the 2026 were just issued now. And they will be kind of basing all their general authorizations on those nationwides and regional general permits that apply to Colorado. So they will not be issuing one for cranberry production probably, but all the others that are normally used in the state, they will be. Until the general authorizations are issued, they are issuing temporary authorizations, and I'll get a little bit more into that. And they also have created an isolated state water general authorization. So temporary authorizations right now, they are issuing them. And right now, they're not requiring fees. I'll get into the fees in a little bit. You need a temporary authorization if you are in non-waters of the US and you think you're in a state water, you don't have an exclusion or exemption. And your project would have required a PCN from the Corps. But say you have an outfall project in an ephemeral stream, outfalls always require a pre-construction notification. So in that instance, you would need to apply for a temporary authorization. Or your project is exceeding the mitigation thresholds, which are a 10 acre for wetland impacts or stream. You are not required to get a temporary authorization if you're in waters US. If you are in isolated state waters, again, that more goes to that general authorization. You can proceed without a PCN under the nationwide or RGP. So again, if you were doing like repairs to a bridge, then you would potentially not need to notify them. Or you, again, fall under those exemptions or exclusions.
Oh, Moneka, I have a quick question. You don't need a temporary authorization if you're in isolated state waters unless you exceed the 1/10 of an acre. I mean, are they gonna then have a special thing for
I think
isolated
right now you can get an actual coverage under their isolated general
Oh,
authorization if you're under those thresholds.
Gotcha.
And then if you are over those thresholds, then it would automatically trigger that temporary authorization.
Gotcha.
So
Okay.
sorry, that.
No, thank you. Yeah, thanks.
So there is a form that you complete online for these temporary authorizations. It's relatively simple to fill out, but very similar to the PCN form from the Corps. Again, they have a lot of information on their dredge and fill website, so I would encourage you to take a look at that website as well. So the temporary authorizations, the division has 15 days to notify you if the submittal is deemed complete or if they need more information. Once they've determined it's complete, they have 45 days to review the application. I believe those time periods are the same time periods that would apply for those general authorizations when those are issued as well. Temporary authorizations are valid for 2 years. Isolated state waters authorization, the bill had said they had to create a general authorization for isolated state waters as quickly as possible, knowing again that they maybe were taking jurisdiction over some stuff that was not regulated in the recent past. However, they've made this very narrow, so this general authorization would not apply to fens, peatlands, or kettle ponds, or to projects exceeding the mitigation thresholds. So over 1/10 of an acre of wetlands or 0.03 acre of stream bed. So it seems likely that most of the time you would not fall under those thresholds, but if you do have a little wetland pocket that's, again, not within 100-year floodplain or 1,500 feet of an ordinary high water mark of other state waters, then you can get it. If it's under a 10%. Individual authorizations. So this is very similar to what Mary said on the Section 404 program. They mimicked it for the most part, but there are some differences. It is going to be required when you can't get under those general authorizations that they are issuing. And it's similar again with the requirements, except the first bullet I have under requirements is a little different than the 404 federal program, and that they want you to submit a purpose and need statement prior to submitting the application. So you have to come up with your purpose and need and submit that, and then complete a pre-application meeting with them within 30 days of that submittal. And then you submit your full individual permit application. You also have to do an alternative analysis, which is similar, but you also have to include a comparative analysis under the 404B1 guidelines. So the 404B1 guidelines is part of the federal regulations under compensatory mitigation. Most of the time, the Corps on like a normal individual permit project is doing that 404B1 guideline analysis on their own and not requiring it of the applicant. The state is now saying you have to do that on your own. And the 404B1 guidelines are a lot more on the whole aquatic system. So are you impacting aquatic fish? What is the effect to water patterns? What is the effect to wildlife? Like very more detailed in that aquatic impact analysis. So you may need to bring in an aquatic biologist or a geomorphologist or others to help with that analysis. Again, depending on the project and the complexity to it. They also have put in regulation requirements on water quality control measures. So this is somewhat tying to the 401 program, and that the 401 is really triggered when you are in a 404, when you are impacting waters US. So now if you are not in a waters US, you don't technically potentially need a 401 certification, but the state still wants to have those water quality control. So they may require a certain amount with this authorization. And then the division, the regulation specifically says they have up to 2 years to authorize an individual permit project. So that's a pretty long time.
Wow.
When the bill was going through, I tried to push back a little bit on that 2-year time frame, and the division had said 2 years should really be for the larger, more complex projects like water supply, reservoir projects. And that it should be quicker for more standard like stream realignment or development individual permits, but
Using that word should a lot.
yeah. We'll see. They could take the full 2 years, so plan ahead. The bill also says they can consult with other agencies. So Colorado Parks and Wildlife specifically, they have will consult with Parks and Wildlife on any individual permits, on nationwide permit 13, bank stabilization, or nationwide permit water management. Or any nationwide permit 27, so aquatic habitat restoration. I think all those will trigger CPW consultation. So that'll also be interesting because I've had experiences where CPW can be very reasonable, and I've had other instances where they can be really difficult. How much the division take into consideration of their comments will. They could also consult with Colorado Water Conservation Board or the State Engineer's Office if there's water right concerns on your project. Colorado Department of Agriculture, if there's ag concerns on your project. Army Corps of Engineers if you have a federal and state needs. And they say they may consult with Colorado State Historic Preservation Office. And in temporary authorizations, they do have a checkbox of saying, have you reviewed for cultural resources? But what's not clear is if I don't believe they would actually consult with SHPO on if you actually had a cultural resource that was being. So that is another TBD that would play out if you had a cultural resource.
Do not check that box. Personally.
Oh, and the other one on this one that I did want to mention is they will not be consulting with Fish and Wildlife Service. So if you have threatened endangered species habitat, like say you have Preble's habitat on your site, then the best thing to do is see if you have a Waters of the US and get a federal trigger because, and Mary may get into this if we have time on the Endangered Species Act, but the Section 7 consultation is with federal agency to federal agency and is a lot easier. If you don't have a federal trigger, you're potentially in a Section 10, which is a habitat conservation plan and can be a lot more time consuming and difficult. But the state will not be consulting with Fish and Wildlife if you have to do that on your own.
With that little shocked face, come on.
Okay, 8710 is the compensatory mitigation section. It is very, again, similar to the federal program and just slight revisions from where the 2008 mitigation rule had language on. It was slightly modified to fit the circumstances of the state and added clarifying definitions pending a lot of stakeholder feedback. The one kind of main change was to the mitigation hierarchy. So again, the state understood that maybe there's not as much flexibility right now at the federal level, and so wanted to add a little bit more flexibility. So they both have said what is best for your project that you can propose any one of these, but this will be the general hierarchy that they follow. And then they added number 3, which is this advanced proponent responsible credits, which is on this slide. So advanced permanent responsible mitigation would apply again, maybe for more larger projects, like reservoir projects or other, projects that would have a significant amount of impact. So this is only for sites that would need more than 3 acres of mitigation. But it would help for, again, say you are building a reservoir and you would need mitigation that you are creating your own almost bank, but not having to go through the banking process like it has been at the federal level. So allowing for, again, mitigation to happen ahead of a project, but not requiring the complexities that banking may require. The regulation also says that you would need to potentially do a functional assessment with any mitigation projects. It has, again, left it relatively open for what you want to propose for a functional assessment method. So there's the FAC-WET assessment that's used most commonly here for wetlands. And then the Corps has been using the SQT, stream quantification tool. You could also propose that, or you could propose potentially using FAC-WET for ephemeral stream analysis, or some other method that you want to come up with. The idea had been that they should create their own potential functional assessment or provide some guidance. We will see again if that comes out anytime soon. Okay, fees. So this is kind of the biggest thing, is that there are some major fees that I don't think we have been accustomed to, because the 404 program has never really required fees. I think there technically is maybe $150 fee that you're supposed to have for an individual permit, but they don't usually require it. So for temporary authorizations or under a general authorization that does not require mitigation, you have to pay $4,320 per year until certification of the project completion is issued. And you need to pay that when you submit your application. They haven't been requiring these fees yet, but I think come mid-April, when the program becomes officially underway, they will. So that means that if you have to get, say again, a submittal for an outfall, and that doesn't trigger mitigation, you get the authorization, but your project gets put on hold for one reason or another, you're paying that fee every year until the project is fully complete. So,
So don't submit until you're really ready to
yeah,
go.
exactly, exactly.
Is that fee just for that purpose only, to submit when you're ready? Or is it just for like upkeep of?
It's, I mean, really, they said it's to help fund the program, period, so, but yeah, that's what the fees have, how they've determined it. They want it per year to help with their, monitoring and maintenance.
But earlier, the wetland mitigation bank credits are sometimes negotiable. How about this?
Yeah, no, sorry, I don't think there's that. So then it's $9,000 per project per year if you do require compensatory mitigation. And I believe this even includes banking. So if you buy mitigation bank credits, then you still have to pay that higher fee in every year until your project is complete. Consultation, so you just want to consult with them to see kind of what permit you need. They say up to 2 hours is free, and then after that, it's 180 per hour. And then if you need an individual permit, it's 180 per hour, beginning with that pre-app meeting, and then 9,000 per year after that. So, projects under Nationwide Permit 27 only have to pay $500. So maybe you can try and get that permit. So, pretty huge.
Yeah. Another
Yeah.
good reason to try to maybe think about doing funding in our state a little different than fees.
Did you have a comment?
I was gonna ask, like, when they were talking about this fee table and setting this fee table, did they consider, like, most of my clients, when they see this fee table, they're like, yeah, we're gonna roll the dice. We're not paying that. We'll roll the dice with a violation. So did they consider like lowering the fees at all to get people to actually pay versus like how many people just aren't gonna do the permitting?
That's a good question. I know they got a lot of comments on it, but how much they didn't seem to budge on it at all.
Violation, have you tested this?
To my knowledge, no one's been caught yet, so I don't know.
Yeah,
But I don't know, like the enforcement section, like, is there really a true enforcement section? Like the Army Corps can enforce $56,000 a day for up to 5 years, right? I haven't seen a section like that in Reg 87.
Oh, I do think, I thought there was a violation section, but I don't remember off the top of my head. But I know that was a discussion with them.
They've got to have one in there somewhere.
Yeah.
I mean, I just can't imagine they would have, yeah, because, I mean, they have to have one. Maybe they just referenced the Corps one.
Yeah.
Or something, but
I
I mean, to be honest, it's gonna be one of those, it's like with the Corps, it's uncommon to just get the Corps isn't running around looking for violations, just like I don't think the state will be. I think it's gonna be similar to like, oh, CDOT's going by and, or an adjacent property owner, oh, I don't like this development, maybe I'll call the state and see if they have a permit. So it's gonna be a lot of that kind of turning somebody in sort of thing. So, yeah, we'll see. Half the state probably doesn't even know.
I mean,
it
they do-
exists.
They do say they could issue violations. They don't say a specific cost, but they say a cease and desist order, cleanup order, restraining order, or impose civil penalties. So,
There was a comment over here?
Yeah, so like if you go to state inspection, where there's the same people that would be like in charge of this, so if you didn't have a permit and you got a state inspection, they're going through all your records, they asked if you have this permit or this, that's how they could potentially catch you.
They could.
Yeah.
That's a good one. Yeah. I mean, it's actually different people, but,
I wouldn't
I
be surprised
would
if they're
not-
training the
yeah, because
town
that's,
staff. on
those
it.
are people eyes on. Absolutely. That's a good, really good one.
And the other thing is we do a lot of like development reviews and putting in the requirement that they have to tell us. They don't have any provision and approval to work in this. As for, I've even started now putting in statements that, you know, if it's not a Corps of Engineer or a federal, whatever, jurisdictional. Just find out if it's.
Like, how does a single family homeowner who wants to do a small little project on their property afford that?
Yeah.
They can't.
We're talking about the develop, like a big development.
Yeah, that's different. But like this, like,
Yeah.
you know, how would you afford that? And my public comment to this fee chart was, this seems not in the best interest of preserving the environment. It seems in the best interest of making money for the state, which is not.
Well, and again, they specifically said in one public stakeholder meeting, it's to fund the program. Which is not, again, the right.
That's not the right answer. Yeah, I mean, they can't raise taxes to pay for it, but they're mandated, but it's an unfunded mandate from the state. And the only way the state of Colorado can pay for things is through fees. That's why we pay so many fees, because we just have the Tabor amendment that really kind of puts us in a bind. So instead of everybody contributing to run this program, the people who are using it, small property owners, are the ones paying the bill. Although they probably don't even know it exists, you know, so I'm gonna guess until the thing gets up and running, there's gonna be a fair amount of, education and maybe after the fact authorizations. Hopefully, a lot of this stuff, you know, they can get it done fast. I don't know, this $9,000, just holy crap. If it's a large development, I mean, it could take 10 years to do the whole thing or parts of it. And if they have to start paying these fees, let's just, and they haven't even disturbed some areas for many, many years, that's just silly. Well, hopefully they're doing it smartly and strategizing. They do the work in the creek and be done with it,
Yeah.
but not the whole development, because, yeah, you know, they're.
Put a pipe in, it may not go anywhere, but at least you've got the pipe.
Yeah, trying to get it done.
There's some existing like pond areas that are suspect.
You see a lot of orphan flared in sections. Stuck.
Like very.
They didn't do the rest of it either direction. They stuck the flared in section where they, anyway.
It'll become
Interesting.
historical.
All right, okay.
There's a question in the back.
Oh, yeah. Thank you.
So my question is like, you said that certain activities could be permitted and need to pay fees or something under both and the 404 and the state, which looking at the exemptions, I think lots of 404 permit is exempted under this state, or they are in general like overlaying.
That's a good question.
I would like to understand like when actually you need to apply for both or one, or like, because exemptions themselves doesn't mean that you are exempted from one or the other.
I feel like the exemptions are, the state tried to make a pretty good effort to have the same ones. So there is some consistency. But I do think you have to just read through really carefully. Hopefully, it's not very common that you have to have 2 permits for one project, right? And hopefully if it's exempt in one, it's also exempt in the other. I think that was one thing the state tried to do as best it could.
Let's say you are like doing regular project which you do in the rivers, right? So you might qualify under the general permit under the 404.
Yeah.
Do you still need to go for the state?
And that is a specific exemption. If you have an active 404 permit, you
Right.
do not need a state authorization.
Okay.
Yeah,
Thank
no, thanks for adding that clarification. Thanks for adding that. One thing that the state is saying, like, so the RGP 7 that the district has, as I understand it, and as the regulations appear to be written, they will also apply that RGP to work in state waters. So in other words, we already sort of, and Monique is going to help confirm this, we already kind of have, they're going to say that what we do in state waters that is consistent with RGP 7, they will authorize under the same thing. So it's kind of nice. We don't have to try to get a new RGP with the state. We can just use our existing authorization to cover those activities. Knock on wood, that's the case.
So if they have similar exemptions, and what's left to that the state would manage?
Oh, a lot.
All the federal streams. And then the other thing is that there's a new proposed rule out that could even make like intermittent streams become non-jurisdictional and not regulated by the feds. So that becomes then maybe more that is under the state program than what we're okay, only 3 minutes. Do you
We
want to
got-
hit the other side?
We got 3 minutes.
Do questions.
No, well, let's see, just real quick. I'm not gonna really talk about that, but just be aware, obviously, there are things that are attendant with all these permits. The feds have all these nested pieces, right? And so you're getting your section 404, you also need to worry about the Endangered Species Act. Who's ever had a Prebbles jumping mouse on their project? Anybody? Oh, right there, right back there. Anyone else? Over there, there. Thank you, Isa. Oh, a couple online. All right, so believe it or not, they are rare, even though we all have a lot of hands. But they happen to occur in this area, and same with the Ute ladies tresses orchid. So we do have some species that are sensitive, so be aware of those. Cherry Creek, Plum Creek, Boulder Creek. The Migratory Bird Treaty Act doesn't necessarily get triggered by just the 404, or none of you do, but it is, you need to be aware of it.
I would say,
Oh, go ahead. I was, again, get a good consultant on board to help you with this, but it's more about timing than anything.
and I would say it's more often that like there's the public that gets you in violation than, and there's no CPW or Fish and Wildlife aren't coming out to double check every bird. But there's like the residents adjacent to your project that are watching that raptor or bird and they like, oh, they abandoned because of your project. That's when you get in violation of that. So it's more of a public relations,
Yeah.
I think, concern than anything too.
You don't want to mess with the bird watchers.
Bird watchers, they'll get you. The other thing that we run into quite a bit, well, we have bald eagles around Denver, quite a few of them, and those construction restrictions can be quite severe, so you want to watch out for that. The one thing we also run into a fair amount, especially down in Douglas County and some other places, are cultural resource impacts. Those can also really slow you down and gum up your works. And I like to say this photo, the woman in the back, when she's happy, watch out for your budget, because that means they found something cool and you're probably you're probably gonna pay a lot of money because you got something cool and it takes a long time to go through that. So that's my little thing on that. Compliance tips, we already talked about this. Coordinate, don't be afraid of the regulators. This is what we do now, right? It's just part of the process. It is what it is. Be really clear on roles and responsibilities. Get your environmental compliance people in at the start. Don't hand them a plan set and say, here, go get a permit. Sometimes that still happens to us and it's like, I had a bridge here's the bridge plan, go get it permitted. Well, they had straightened an oxbow under the bridge and the Corps, Rex Fletcher, anyone remembers Rex? He was like, nope, you can't just straighten the creek. So I had the pleasure of going back and saying, sorry, that plan set you handed me, you got to go back and redesign the bridge to accommodate the oxbow. So bring your complaint. I could have told them that from the get-go, and maybe we've had conversations and they could have gotten it done, but Rex was like a no way right from the start because they didn't check. So develop a good approach and then make sure you just follow through design, construction, monitoring. Make sure everybody has responsibilities for it. If you see something, say something. Better to stop, make sure it's right, talk to the regulators, and don't just kind of whistle past the graveyard on potential violations. I think that, there's some more, but there we go. All right.
Give these two.
1 minute over. Thank you, everybody online. I know it's kind of tedious to listen in online, but thank you so much for sticking with us and for the few questions that we got. Really appreciate it. And I like to put myself as a public agent entity. I'm here as a resource for the region. If you have any questions, I'm happy to chat with you, send you to other people who know more than me, but I don't get tired of talking about this after 33 years. So happy to answer questions or try to find resources for you. So